Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. I took Saturday off. I'm recording this on Sunday, the 29th. I took it off. I rested. Sugar Bear rested. He was feeling a little under the weather. So we just snuggled and watched TV and ordered yummy takeout or delivery. I thought I was going to feel guilty about it, but I don't. But I'm back and I've got more Sarah Boone madness. I How do I want to phrase this? I was looking back at what Sarah was accusing Brian of lying about. And so then I remembered there was one of these documents that had all of these like visitation dates that she wanted, and I found it. And we went over some of the lies in that, but now there are more things that I've refreshed my memory on because it had been a while since I looked at all the family court docs. So I want to go over those with you because there are more lies. And a lot of these on information and belief from Lana were written in concert with Peter Gunthal and Nicole helping her write these. So I don't know if she's like legitimately bamboozled them, if they're all in, if they don't understand the law, or they just don't care that she's lied. But I've even looked up some case law, and some of the case law, most of it doesn't apply, but some of it is a real stretch. So let's get into it. I'm going to play the intro. Thank the members. Thank you for being here. I appreciate you. And then we're going to get into the good stuff. I'll see you on the other side. Okay, so at the heart of all of this, Sarah wants money, right? That's really what she wants. She can say these other things about wanting custody of her son and to be involved in his life, and in the sense that it helps her feel in control, I would agree with her. But in the sense of like really being a loving mom and caring about her son, it just ain't there, sis. It just ain't there. So I want to start where all of this kind of jumped off, right? So she was arrested February 25th, 2020. Brian stopped paying the full $1,000 alimony, and he didn't pay any of the $100 child support. He didn't really file for anything until 2022, which is when he filed for the modification of that, of modifying alimony and asking why is he paying child support if he has the child all of the time, which is reasonable, right? And in the state of Florida, you have circumstances that allow you to apply for a modification. And so he did that. A year later, so in 2023, after not getting any money for 3 years, Sarah decides to pipe up and file for motion for contempt. This is before Brian is going to file for the motion to relocate, which is granted in 2023 on a temporary basis. But I want to start with the motion for contempt so we're all on the same page. This is written by Sarah, comes now Sarah K. Boone, submits her motion for contempt for non-payment of alimony by Brian C. Boone, the petitioner, and in which was court ordered by Judge Michael Dean to continue being paid to respondent in the last and only status hearing 9/19 2022. There's no documentation that it was ordered. You'll see in one of the more recent ones, she's claiming that it was oral, but it's not even in the minutes. So she's misremembering. I'll be kind because we're just getting started. So I'm going to start off kind. She's misremembering the facts. So since, during, and prior to respondent's incarceration, I don't know why she says prior, because she's been incarcerated, like I said, since February of 2020, February 25th to be exact. So if it was prior to that, It's not really related to her. It's not related to this. That would have been separate and apart. She should have filed. Anyway, petitioner has completely withheld and or diminished incredibly the promised $1,000 monthly payments. I would have said ordered if I were writing it, but I'm not writing it. He has not completely withheld. We looked at the payments, at least that he was making in 2024. He was still kicking her some ends every month, not to the tune of $1,000 a month, but we saw she was only spending like $200, $250 for the year. And the majority of it went to candy bars and then baked goods and then sugar or sugar substitute. She's claimed stating that repeatedly he said that she is not important and not priority. That's all hearsay. We have nothing to corroborate. We just have Sarah's word and we know. What did Chelsea say? Oh, okay. This money owed to the respondent is overdue, ordered, and needed, being the only source of income to make any and all necessary purchases. Also, petitioner agreed to, signed, and made responsible for all said payments in the active, all caps, court file dissolution of marriage 2017. I believe it's actually dated 2018, but let's not get too petty yet. Respondent is seeking all delinquent and arrears payments, which would be one and the same, and all full current payments of $1,000 going forward to be made to the designated account of her choice. Respectfully request this honorable court to please grant this motion for contempt, entering its order for alimony payments, delinquent and arrears, to begin immediately and without difficulty or confusion, by Brian C. Boone. So that's Sarah. So this is before Bankowitz comes onto the scene. He will later step in pro se to help her, and then he'll step out by the end of 2023, shortly after he withdraws from her criminal case. So then immediately thereafter, Brian's team files a motion to continue contempt hearing scheduled for May 11th. So when she filed that motion for contempt, there was a contempt hearing scheduled for May 11th. They came in and were like, whoa, 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 not so fast. So comes now petitioner Brian Boone. I'm just going to go. Number one, on April 11th, 2023, respondent filed a motion for contempt alleging that the petitioner is not paying his ongoing alimony obligation. April 14th, the court entered an order scheduling this motion for contempt for a hearing on May 11th. The petitioner filed a petition to modify alimony on April 12th of 2022, so a year ago. And that petition is still pending as of the date of this motion. Under the current law, the petitioner is entitled to have his petition to modify his support obligation heard and resolved prior to trial court's resolution on respondent's later filed motion for contempt for failure to pay support. So the words are important. Later filed. Had the motion for contempt been filed first, it would have been heard. But because he first filed for the modification, that has to be heard first under the current law before this contempt motion. So as a matter of law, it's not up for discussion or negotiation or judge's discretion. It has to be. See Rosenblum v. Rosenblum. Therefore, petitioner is requesting this hearing be canceled and rescheduled either contemporaneously with or after the final hearing on modification. So the hearing on modification needs to be heard. And at that hearing, the contempt motion can be heard, or after that, subsequent to that, or subsequent, depending on where you're from. So that was on April 18th by Brian Boone. And then, lo and behold, the court agrees and defers to the law. So having come before the court on April 19th on the petitioner's motion to continue contempt hearing, having reviewed the file and being advised in the premises, it is therefore ordered and adjudged as follows. The motion is granted. So what does that mean? Brian is not in contempt, and the motion to say he's in contempt cannot be heard until his motion to modify is heard. And it can be done on that day or thereafter, right? So he is not in contempt, even though despite him not being in contempt and not being able to be, and she not being able to be heard about him being in contempt until after his motion is ruled on, Sarah keeps saying he's in contempt. She's alleging he is, but it can't be heard. So it's just an allegation. But she absolutely keeps saying it like it's a matter of fact. and it is not, right? So the hearing schedule for May 11th is canceled and will be rescheduled either contemporaneously with, at the same time, or after the final hearing on the modification. So not any pre-trial on the modification, not any continuances, not any, I don't know, check-ins. The final hearing, which now is scheduled, we know, August 25th, 2025. So at that hearing on that date, we can hear the motion for contempt or sometime after, right? Court retains jurisdiction, and that's when we still had Michael Dean. So I wanted to lay that as our foundation before we get into this filing of Sarah's where we detect all the lies. And oh, get your pens ready because there will be quite a few. So this was filed this year in March. Okay, so I'm not going to go through this line by line. Like I said, we've gone through it once. I just want to pick up and grab what, when I reviewed it again, stood out to me as lies. Now, this is like the third motion she had filed for the year, and this one she's pretending she wants more rights with her son. So you'll see here, enforced child custody agreement for sanctions and for relief due to parental alienations. What kind of sanctions? Money, money, money. She wants anything
to get the money, right?
Enforce alimony obligation, and now she's adding recovery of property, which has nothing to do with her divorce. I've said it before, but some people are like, where is that coming from? I'm going to show you in these documents today. And then grant a continuance. We're moved beyond that. Oh, I should say reconsider contempt of court continuance. So that's why I wanted to start with the contempt of court, because by law, it can't be reconsidered. It's not that it's been denied. It just cannot be reviewed until his motion has been reviewed. And so, like, the people helping her, I don't understand why they keep adding this. Like, instead of just telling her it can't be reconsidered until his motion is heard, they keep rehashing it, which I'm sure the judge just loves.
Sarcasm.
We're going to start here. Following the respondent's incarceration, the petitioner ceased making court-appointed alimony. She's going to say that and child support in every document. But why would he be paying child support if he's providing sole support as a single parent? She's sitting in a jail cell. It doesn't make sense to me, but apparently to the people helping Sarah, it's worth reiterating. Petitioner made sporadic payments, which is not true. He made monthly payments. It just has happened to be below the alimony obligation into her jail account. Here she says jail account. Later she'll say he was making it into her account that she had since, I don't know, 20-something years, and then it's closed because of him. Here she just goes right to jail account and doesn't get into all the fluffery. Further, petitioner ignored the respondent's repeated request to communicate with her minor child and to be included in major parenting decisions. I meant to underline that whole thing. I think I got distracted. She doesn't specify what she considers major parenting decisions or give any examples of decisions she wasn't included in. So this to me is just like a control of like puffing her chest. I should be included and I don't have any examples, but I'm sure there's some major parenting decisions he did not include me in.
Okay.
She goes back through rehashing this. She mentions the parenting plan. The court verbally instructed petitioner to resume alimony payments and comply with the parenting plan. Again, no record of that happening. F. Thereafter, petitioner continued to defy the court's order, failing to facilitate visitation with the minor child and not meet his financial obligations under the final judgment. She keeps lumping them together. Visitation is separate and apart from financial obligations. I would have written them. Now, mind you, I'm not a lawyer, but neither are the people writing these motions. So I'm saying if I also, as a non-lawyer, were writing these, I would break this up differently and just keep the visitation separate from the financial obligations. However, I want to point out, and we've already gone over the parenting plan. We did that in the last video, but I'm going to bring it up for old time's sake because there's no way he could follow the parenting plan as it is currently written with her being in jail, being incarcerated. I'm saying that because it's going to span over her incarceration in jail and now currently in prison. And she uses documents from my YouTube channel as evidence to support it, but they're very, and I say they because she couldn't have done the screenshot. So it's either Peter or Nicole. Because this was written when it was March 20th. She's not speaking with Lana anymore, right? In fact, let's just go there right now and we'll come back since we're talking about not allowing visitation. Okay, here we go. And I didn't notice this before, honestly, because I was so weirded out that my document was appearing in a court document with this was the old stamp on it. She's only selecting 5 of them. 1, 2, 3, 4. Oh, it's more than 5. 1, 2, 3, 4, 5, 6, 7 visits out of all of the total visits. And you notice she calls it Exhibit B, respondents' virtual visitation schedule. So she's not talking about phone calls. She's talking specifically about the virtual, what she's calling virtual. It's the video visits, right? But she only selected the ones where he didn't show up. But I want to show you the dates. This is Christmas. And Brian showed up for this at 6:48. The son was a no-show. So I wouldn't say that Brian was keeping the son from her. I would say more the son didn't have time. Maybe he was on the phone with his grandparents, Brian's parents, right? Also, these are not in chronological order. We have February 23, and then we go to July of 2023, then we go to March. So I don't know what they were. They just cut and paste, right? But here we have on Valentine's Day, and I'm going to show you guys the full report because for whatever reason she wants to see them both on Valentine's Day. And notice it's at 7:00 at night. Like, what if Brian had a Valentine's date? He's got to be looking at her. Or if the son had a Valentine's Day date, something cute, you know? Anyway, so son was a no-show. Brian was there. Then we have 7:24, just an arbitrary day, 1 in the afternoon. I'm going to guess it's a weekend. Neither of them show up and they don't cancel. March 5th of 2023, son doesn't show up. Brian does. This is the son's birthday. This is October 28th, 2024. So this is the Monday after Sarah is convicted of second-degree murder. And it's the son's birthday. So neither one of them show up. And it's at 9:00 at night. It's his birthday. Does he, like, you and I know it was going to be a pity party for Sarah of like, oh, the jury got it wrong and how could they do this? And, you know, why I wouldn't have gone either, quite frank. I wouldn't have gone to any of these, but you know what? God bless Brian. Then we have, did they cut that twice? They did. Mommy. This is the same day. That's why I didn't pick the other one. 10/28/2024 at 9. Yeah, babe. That's not for me. That's for the dog, for the vet to give the little doggy a shot. Where's the little doggy? Does the doggy need a vaccine? Yeah, this is a duplicate. 10/28/2024, 10/28/2024. I must have had 2 separate reports. One where the jail redacted it because that's their redaction. These little scribbles are my redaction. So interesting that they put that in there twice. Either way, it was the Monday after her conviction. She was convicted on Friday, the 26th. Is that 26th, 25th? Then we go back to 2023, and then this is 8/27/2023. No show. Okay, so that's what she submitted as an exhibit. But look at here. What do we have? The full visitation report. I want to clarify so nobody gets confused. This is the report from 2/25/2020 when she was first incarcerated to 1/13/25, which is when I asked for this report. Their first visit is not until 2021, so like a year later. So that first year, I don't know why. Obviously, the jail doesn't give me any explanation. And then in the options include cancel. So there are times when they no show, but they cancel. So she would have advance notice. But it also could have been canceled on the jail side if something happened, right? So it's not always attributable to Brian like Sarah wants it to be. I don't know why I air quoted Brian, the real Brian. So here we have 4/25. There's a visitation of 2021, 5/9 of 2021, 7/23 of 2021. They're both there. 7/31 of 2021, both there. August of 2021, August 10. They're both there. August 28th of 2021. They are both there. October 10th, 10/10, Sarah's birthday. They're both there. 10/28, the son's birthday. They're both there. Then we have November 29th, it's somewhere around Thanksgiving. I was going to pull each of the days of the week, but then it was getting long. I didn't want this video to be too long, and I didn't want to have to work on it too much longer. But I think that's around Thanksgiving. No show. 5 p.m. Neither Brian nor the son. December 5th, 2021, they both are there. December 6th, they canceled this one, which makes sense. Like maybe they were trying to see which one was better. This is at 5 p.m. and this one was at 2 on the 5th. So 5 on the 6th, they just talked to her the day before. Then 12/12, December 12th, Brian shows up. Son does not. Then we have on Christmas Day, they both show up. January 9th of 22, child is a no-show. Brian shows up. Valentine's Day, again, they both show up. 6 p.m. at night is this meeting. May 8th, they both show up. June 23rd, the child does not show up. August 10th, of 22, child does not show up. 9/11/22, the child does not show up. For context, he's born in 2010, so I just go by the years. He'll be 12 on his birthday in October, so he's 11 at this time. October 1 and 22, they both are there. October 10th, 10/10, it's her birthday. Child does not show up. Brian shows up. I mean, he's a glutton for punishment. God bless him. She can never say he did her wrong. Like, I would not show up to my ex of many, many years for a video visit on her birthday while she is in jail for murdering her boyfriend and recording it. October 30th. So it looks like we've skipped his birthday, right? Yeah, October 30th, no show for him. Brian shows up. So it's not like she can say, oh, he intentionally had my son somewhere else on our visitation, or there's just nothing to show that he's withholding the son from her. Do you know what I mean? He's showing up. I mean, what's he supposed to do? Like, what do you do? Tase him to get him there? Like, I don't understand what she wants. December 5th of 22, son doesn't show up. Brian is there. Christmas, he does not show up. Son, Brian does show up. 7 o'clock on Christmas evening. Now we're into 23. So the 28th of January, Brian doesn't show up, but the son does. So that blows up my theory of like, maybe he has to have the dad there for the son to be there, because clearly they let the son talk to her. I just never see it booked with just the son, so that's why I was like hypothesizing that maybe it required the dad. Valentine's Day of 2023, child does not show up. It's at 7 o'clock at night. Again, what if Brian has a girlfriend? Maybe he doesn't want to talk to you, Boone. Then we have March 5th. The son does not show up, but Brian does. We're in 23. Then we have... there's a stretch here. And this is when we start getting our tablet messages. So there's a lot more. Well, they could have been talking via tablet earlier. Although I noticed he doesn't respond. The son does not, well, Brian doesn't either, respond to her via tablet. So many of you guys made the point of maybe he's never even seen these tablet messages, which I hope he hasn't. And then if he's seen them because of me, I'm sorry, sir. I didn't tell all the heinous ones intentionally because I was worried about that. So May 14th of 23, they both show up. Then we have both are no-show on the 18th of July in 23. This is around the time of the relocation. I'm sure she was guilting them about it because she's really upset that it's beyond the 50 miles and that they're calling it temporary. She accuses them of lying. Like, it's not temporary. You guys know it's not temporary. Kind of foreshadowing her own, not even foreshadowing, just indicating she knows that her situation is forever. That's the only reason why it wouldn't be temporary. So July 24th, neither of them show up for that appointment, but July 31st, they both show up. August 14th, they both show up. And on August 27th, neither one of them show up. And this is after she's been denied her motion for contempt, right? And definitely the house is sold. Here we go again. 10/10/2023. Must talk to mommy and sing happy birthday. They're both there with her on her birthday. And then on the son's birthday, they're both there this time in the morning. Brian's birthday is May. I should have looked for that because his birthday is around mine, but I think like before like May 2nd, May 3rd, somewhere around there. Okay, then we have on December 3rd, they are both there for the video visit with Mama, with Mommy Dearest. We see Hobson has entered the picture. Jody, that is the therapist on the swing. I wonder why they didn't count her as part of the psychiatric. Oh no, because Harper didn't review any of her psych files. That was why. We don't know. But definitely that woman is a therapist. Okay, March 10th, both of them are there. Father and son dutifully waiting on Mommy. April 6th of 24, they're both there. What was there? It says 2 to 2:04. I'm sure they were there longer than that. The 20th of April, they're both there. The 12th of May, they're both there. And Christina shows up on here, so she's been released from jail. I think in April she was. Patricia Cashman is here. Poor thing. Getting hung up on. She canceled. Good for you, Patricia. Let's see. Pearl Walker, Marlene Walker. Isn't Pearl Walker the black lady who used to see her when she was sitting out on the porch or whatever? Who was like, oh, she'd be beat up. Poor Pearl. The older lady, you guys know who I mean, who did not come back at sentencing to speak for her. 10/11. So this is the first time we don't see a 10/10 visit with Sarah. Now, mind you, she's in trial at that point, right? Oh no, wait. It was originally 10/7 and then there was Milton. So when did it start? 10/14? Because we were all like, oh yeah, she'll be in trial for her birthday, but then it didn't happen because of the storm. We knew when it said Milton, Owens is from Milton. We're like, he's sending the storm to help her. And he got another week out of it, like, before trial started. So this is the day after her sentencing. I just wrote that on there. She's talking to her clergy, who the clergy did not show. Add an insult to injury. And then 10/28 is the son's birthday. There's the no-show. The dogs, let me go back. So it's the son's birthday. There you are, a no-show. This is the Monday after her conviction, not sentencing, but her conviction. Then we're in December. Sentencing day that morning. Peter and Julian did not show up that morning to talk to her before she was sentenced. I don't think they wrote a letter for her either. We know they did not show up in person. And then Christmas again, daddy and son dutifully at mother's feet. And then that was it for her visitation. But I know I just scrolled a whole bunch of things for you. So I set this up so that I could make a little collection of what we had. So all total for her visits, there were 42 scheduled altogether, 36 that happened. So 85%, 36 of 42. 85% of the scheduled visits happened. And then of the ones that did happen, the son attended 24 of them, or 66%. And I highlighted the patterns, just that helped me see like her birthday, son's birthday, Christmas, Valentine's. Not Mother's Day, not Thanksgiving, not Easter. These were the important ones, the totals. So he saw her 36 times the son appeared 24 times from 2021 through 2024. And we know, based on what's been filed in family court, he has not seen her in prison because Sarah was complaining about that without filing a motion. Okay, so we're going to go back to her other document. I'm going to scroll without you guys here just so you can see, because I want to list out what she's requesting for parenting time now, what the relief is that she's seeking. This is her relief requested in regard to her son. Enforce the existing custody agreement and order petition to comply with all provisions of the final judgment and parenting plan. We went over the parenting plan in the last video. He cannot adhere to all of that because she can't have any overnights, right? So that part of it is silly. Establish that compliance is mandatory unless the court formally modifies parental rights. Yes, the court is going to do that. Order petitioner to facilitate virtual calls. between respondent and the minor child, establishing a set schedule for a minimum of 3 calls per week. These are the virtual calls, so the video calls. We know she's talking to him on the phone because during our last check of the calls, there's lots of phone calls with her son. Again, to which I say, what could she possibly have to talk about with him? Like, what is she doing every day that is so, I don't know. I'm an introvert. Y'all know that. So I can't do a lot of phone calls. I find it to be exhausting. Like, people are just talking on and on and on and on and on. That's how it sounds to me. And it just drains me. I can't imagine like what she would be going on and on and on and on about from her day in prison. Do you know? But they talk quite a bit. So for the maximum allowable time afforded by the correctional facility. So not 5 minutes, not 10 minutes. If it's 30 minutes max, she wants 30 minutes every single time. And she's saying order petitioner. But the child is now 14. What if he doesn't want to talk to her for 30 minutes 3 times? That's an hour and a half. Like, what could they possibly have? She wasn't talking to him that much. Let's just be grounded when she was free, right? She barely would remember to pick him up, according to Brian. And I'm sure the son remembers that, or remembers that feeling of not being picked up, being left behind, or being told in the morning, mommy's picking you up, and then dad showing up at like 3, mommy was busy drinking. No, I'm sure he didn't say that, but you know what I mean? Additionally, respondent requires a virtual contact on all major holidays. Again, she was not allowed that when she was free. Here's the holiday schedule from the parenting plan. The major holidays, they alternated. Easter, she got even years. Are we in an even year? No, we're in an odd year. So what would she get this year? She would get Memorial Day weekend. She would get Labor Day weekend. She would get Mother's Day. The child shall be with the father for the entire Thanksgiving school and even numbered. So this year is an odd year. She would get Thanksgiving. His birthday, they would both get him. Seems like he's been consistent with the birthday, and they've been consistent with the parent's birthday, right? As far as 10/10, we see him visiting his mom. 10/28, we see it except for that conviction year, which is, I think, is understandable. So now she's asking for
above and beyond.
Winter break. Parents shall equally divide. So what she's asking for now is above and beyond when she says all major holidays. What if they're in Greece? They've got to figure out how to get to a place to, it's just silly. Like, in that regard, in that respect, he would never be able to travel with his son on any major holiday because they've got to be somewhere, at least stateside, where they can log in. Because I'm not going to be in some other country trying to figure out how to contact my ex-wife in prison. Compel petitioner to include respondent in all major decision-making regarding the minor child. I just don't agree with that. I'm sorry. I don't. Like,
You're not good at making decisions, ma'am.
As evidenced by the putting of your boyfriend in the suitcase and then of leaving him in there and recording it all. You're not a good decision maker. Hold petitioner in contempt for willfully violating the court-ordered parenting plan. Where has he violated it? She doesn't give any specific examples. Require petitioner to complete a co-parenting course. I think that's just silly. They already had to do that as part of the dissolution of marriage. Impose sanctions on petitioner for parental alienation, including but not limited to potential modifications of the custody agreement in respondent's favor. Okay, so here she's asking for a sanction that is not money, but rather that she gets more favor in the custody agreement, in the modifications. What might those look like? She doesn't specify. I would be curious as to what she's considering, but I guess we'll see it in the parenting plan that's due this week, right? I don't know if they count weekends or not. If they don't count weekends in the 30 days, then it would probably be, I think, 2 more weeks, like around July 14th, thereabouts. And then grant any relief this court deems just and proper in the interest of justice and the well-being of the minor child. So that's bonkers part 1. Then we're going to go back up and we're going to look at the money. There's where we left off. Failing to facilitate visitation. I don't see any evidence of that. There's multiple times where he's seen her, maybe not as often as she would like, but she's in jail. She's incarcerated. Now she's in prison. So this, I don't understand what her point is. Like, she says petitioner verbally berated the respondent, referring to her as a killer and murderer, and laughed, mocking her incarceration by stating that there is nothing Sarah can do. So she is technically a killer and a murderer. I don't know why he would laugh. And I don't know that it's mocking saying there's nothing she can do, because like literally there's nothing she can do. She is incarcerated and now she's there for life. She admitted on the stand to being a murderer, but she had a reason for being a murderer because she was reacting out of having a syndrome of being battered. Yeah, so I don't know, other than for pity, why she adds that in there. When respondent asked petitioner via telephone and by tablet about these unmet obligations, she goes into that because later she says the court already told her the tablet messages are inadmissible. So I think it's just for sympathy. This date is wrong. We talked about this when we first looked at it. She actually filed that in April of 2023. His was in April of 2022. So his preceded, which is why I wanted to show you guys the other one first, because his was filed first. It takes precedent. Had her motion for contempt been filed first, then it would have been heard. So again, they're being misleading and then thereby misunderstanding the laws that support the decisions that the court made. Petitioner also continues to deny the respondent communication with the minor child, visitation rights. So we just looked at that, and if you haven't, I don't want this to be too long. Yes. So I'm not adding all the phone calls here, but if you go back, I'll link it. The last video with the calls, tons of calls with the son. And then you saw all the virtual visitation rights, or virtual visitation, video visitation, whatever. He has not been to the prison to see her. No one as of June 2nd has been to visit her. Right? Peter got approved. Christina's not on there. Nicole was approved. That is a lie. She is communicating. No. At least as of June 2nd or through June 2nd. No one's been to visit her though. And I don't know if they have video visits in the annex, but they have in person and he hasn't been. The paperwork hasn't been completed. And who's taking him? Brian is unemployed. Like, who's taking him to visit the mom? And does Brian have to go in and see her too? She's asking a lot. And exclude her from all parental decision making. Again, specifically, what parental decision making? And you're not a good decision maker, ma'am.
No, ma'am.
No, ma'am. So Exhibit A, she shows the tablet messages from my videos. And then Exhibit B, we just looked at what she's calling the virtual visit. She put schedule. So she's going back to when he filed the continuance. She says petitioner asserted the court could not enforce the respondent's existing alimony while the yeah, that's true. He can't be found in contempt because the contempt motion cannot be heard. So the change, I mean, he might be held later, but it has to be after his motion is heard, right? I'm not saying he has no responsibility, because there is the question of he didn't file that until 2022. He stopped paying in 2020. So there is a gap, right? So he could later be found in contempt of that, but she's trying to force it to mean she gets money now. And it doesn't mean that. Change in circumstance was solely due to respondent situation, not related to petitioner's financial inability to meet his court-ordered obligations. And that is why he filed, because she's incarcerated. So he's like, hey, I want to have this looked at. I don't want to pay her $1,000 a month in support of alimony or $100 in child support, because I'm now a single parent. The money is better suited in my household, irrespective of his financial circumstances. So respondent asked the court to provide access to tablet messages, recorded phone calls, and is denied by court, stating it is irrelevant. So that's an answer for all the lovelies who were like, I hope Brian is submitting the tablet messages. I don't know if your voice sounds like that. I'm just saying. And the court said it's not relevant. So it doesn't make sense that Brian would try to submit that or the recorded phone calls, right? They should be able to make their case without those. And really, the messages are just her. Brian never responds. The son never responds. So then she's asking reconsider contempt of court continuance and to sanction petitioner and his counsel. Again, we looked at this. By law, the contempt of court cannot be heard until his motion to reduce or eliminate has been heard. Reconsideration, then she's going to go into detail anyway. Like, this is what my grandma would call somebody who will argue with a stop sign. It's still saying stop, they are still arguing. Sarah will argue with a stop sign. Despite, okay, so let me start from the beginner. Petitioner incorrectly asserts that the court cannot enforce respondent's existing alimony and parental rights while the modification motion remains unresolved, which is, she's twisting it up. What the petitioner said is, the motion for contempt cannot be heard until the modification motion is resolved. Not that it cannot enforce, because it can enforce it retroactively, right? Meaning, because that motion needs to be heard contemporaneous to his motion or subsequent to or subsequent, it can be enforced retroactively. So if it's heard this year in August, the court can then go back and say, retroactively, you should have paid from 2020 to 2022. So it's not that it cannot be enforced. It's the timing of when it is enforced. And she doesn't like that. Peter should be able to explain this to her. I don't think Nicole can. I don't think Lana knew, because I was just starting to give her some of these documents. Like, I think closer to the end when they were no longer speaking, she knew, and she wasn't involved in writing this document. But I think initially she was behind Sarah because she thought the law was on Sarah's side. So despite the fact that the alleged change in circumstances is solely related to respondent and not the petitioner's financial inability to meet his obligations, that is moot. That is not what it says in Rosenblum v. Rosenblum. It just talks about the sequence of what things have to happen. Yeah, so I'm not sure why that's thrown in there, but he has been unemployed since 2022, and that's been shown on the record. I showed that to you guys in the last video. Okay, petitioner's reliance on Rosenblum v. Rosenblum is misplaced, really? And is the court's reliance on it too? Because that is what the court based their order granting the motion to continue. That case held that a party cannot be held in contempt if they lack the ability to pay. Yeah, the judge never said he cannot be held in contempt. Here we go again with the confusion. In this instance, no one has said he cannot be held in contempt. What has been said is the motion to determine if he is in contempt cannot be heard until his motion is heard. Do you see? You guys understand the difference, right? Like, she's being obtuse. Somebody's being obtuse. Like, that makes perfect sense to me. However, Rosenblum requires a show of financial incapacity. This is not as it relates to the actual contempt, not as it relates to the hearing of the contempt. So it requires a show of financial incapacity, not merely a change in circumstances of the receiving party. He has had a change in his financial ability to pay. He doesn't have a job. Here, petitioner has failed to assert. He didn't assert it, I'm going to agree. He said he wanted it because of a change in circumstances and that she was looking at life because she murdered someone. But he did provide evidence of a financial hardship. He absolutely did. His argument is legally and factually deficient. No, your understanding of the law and the facts is deficient, ma'am. Okay, so Florida law mandates compliance with court orders unless a modification is officially granted. Florida Supreme Court reaffirmed that support obligations remain enforceable until legally modified. Again, it still remains legally enforceable. It will just be retroactive. It doesn't say at this moment in time. It still remains enforceable. You're 100% right. But it doesn't mean right now. Nothing can even be looked at to be enforceable until after his motion is heard. Willful noncompliance. A willful violation occurs when a party deliberately refuses to comply despite having the ability to do so. He's not refusing to comply. The court has agreed he can't be held in contempt until after his motion is heard. He's not refusing to comply. I don't see that anywhere in writing where he said, I will never pay this. And then so we go into these. So this is weird. Florida law provides clear authority for holding petitioner in contempt, grants Florida statute 6114 grants the court power to enforce support orders. No one has taken that away. In Lamb v. Lamb, the court ruled that failure to comply with the support order constitutes contempt if the obligated party has the financial ability to pay. Well, one, he doesn't have it. Petitioner has not presented any credible evidence of financial hardship other than he submitted financial disclosures starting in 2022 that he was unemployed. His refusal to comply without justification constitutes deliberate contempt of court. So here she's arguing her motion of contempt, even though she's been told it can't be heard. So we're going to look at Lamb v. Lamb very quickly. This is something totally not related to contempt for not paying. One, they both filed for divorce. The wife filed for divorce based on adultery. Husband filed for divorce based on living apart for 1 year. The Court of Appeals erred in maintaining the exception. They were saying only one filing could be heard or be correct. It doesn't have anything to do with what they're alleging, which was, let me go back over here, not being able to be held in contempt and refusal to comply. Yeah, I'm not sure why they're bringing this in with regard to the contempt, but again, this is not the place to litigate the contempt. It's just not. It has to be, sorry, I sound like a broken record. You guys get it. It has to be held later. It has to be after his motion is heard. Like, I don't know. Then we have let me go back. Boone v. Boone, a party seeking relief from contempt must prove an inability to pay. He is not seeking relief from contempt. So the whole fallacy, like the whole premise of this is a fallacy. Nowhere is he seeking relief from contempt because that is not being heard and cannot be heard right now. But the Boone v. Bowen. Let's look at this quickly. So this was about contempt in general, and they were saying that it was criminal rather than civil, this contempt. Frankie L. Bowen was incarcerated without a finding that he had the present ability to pay the purge amount. So she brought the contempt charges, this woman, Eugenia, who was the respondent, and the court found that it was criminal contempt. And so they put him in jail until he paid the purge amount, the amount to get him out. So he was sentenced down here to 5 months and 29 days in jail with the provision that he could purge himself of contempt by paying the $916 in arrearages plus $50 court costs. Frankie L. Bowen presented evidence that he had been laid off from his job and was unemployed. The court approved the decision of the District Court of Appeals with directions to remand the case to the trial court. So they sent it back down, saying he should not have been jailed because he didn't pay, because he did not have the ability to pay. So it's the reverse. Even though he's incarcerated as a result of not paying. So this is a whole other weird, he did prove his inability to pay. So then that's why it was reversed. But here they're saying Brian should have done that, but he's not seeking relief from contempt. And what we just looked at, he was found in contempt, criminal contempt, and jailed because of it. That does not apply to what we have going on here. Petitioner and petitioner's attorney are using respondents' incarceration and lack of financial resources to deny her constitutional rights. I just put a question mark. Which constitutional rights, ma'am? What happened? How are they? I'm pretty sure you being incarcerated, you already lose some constitutional rights, right? A party may be held in contempt for failing to comply with court orders or for conduct that intentionally impairs the opposing party's rights. So you're right. He can be held in contempt, but not before his motion is heard. So then this, under Bowen v. Bowen, any modification requires clear and convincing evidence of financial hardship, which petitioner has not provided. So we looked at Bowen v. Bowen, and in that case specifically, they're talking about child support, even though here Sarah, Peter, and Nicole, they talk about alimony and child support. Bowen v. Bowen is specific to child support. So Florida law is clear that incarceration alone does not justify modification of parental rights or obligations. So Brian hasn't modified any of her parental rights or obligations as far as I can see, unless she's referring to his obligation to pay, which I would say incarceration alone may not, but certainly if he's taking care of the child solely and singly, there is no justification to be paying the incarcerated person. Elmo? what was I saying? So it doesn't justify him paying her money while he's the child is in the care, custody, and control of Brian. He'd be sending her money for what? For child support. Like, her whole story about just put it in a pot and I get to designate where it goes is BS. But that's, I think in tandem, she's fighting for her rights as a parent, right? Or her decision-making power. And so that's a way to kind of control that. I have decision-making power by him setting aside money that only I can say what it's spent on, including presents for me for Mother's Day and Valentine's Day from my son. So Hunter v. Hunter rejected the notion that incarceration by itself is sufficient grounds for modification of custody. I did do Hunter v. Hunter here, which this one, I don't know what they're tying it to either. District Court of Appeals. This is from 1989. Stuart Hunter appeals from a judgment modifying a final judgment of dissolution of marriage. Stuart and Susan Hunter were remarried in 1976, or were married and have 2 children born during the marriage. So this one, they were alleging abuse, one of actual abuse and the other one of just physical child abuse. And they took the rights away from Mr. Hunter, and then upon review, they gave them back. They took them, the appellate court said, without sufficient foundation. They granting Mrs. Hunter sole parental responsibility as furthering the best interest of the children, observing that although the parents were individually qualified to serve as a parent, their animosity toward each other, their inability to communicate, and most damaging, their use of the children to hurt each other created a negative effect on the children. Consequently, the trial court ruled that sole parental responsibility, obviating the need for joint decision making, serving the best interest of the children. So if Brian gets sole custody or has sole parental responsibility, there won't be any need for joint decision making, right? They found no basis for overturning it, so she kept it. I read a lot of cases today, guys. However, we note that the trial court erred in awarding sole parental responsibility to the mother, absent a specific finding that shared parental responsibility would be detrimental to the children. No? Okay. So they reversed that portion. Elmo's going to have to help me. Give me 1 second. Okay, yeah, I did get this one mixed up. So they originally gave her sole parental responsibility, but then they sent it back to the lower courts. They reversed that and they remanded it to enable the trial court to make the determination required by Section 61.13(2)(b)(2). I'm going to have to look that up for later. To see how they determine responsibility. So next we address appellant's contention that the trial court erred in terminating his visitation rights. Visitation rights may be modified if there is a substantial change in circumstances and the modification will benefit the child. So basically the court will get to decide if, say, modifying it to not 3 visitations a week and 3 virtual a week and however many in person would be detrimental, because who wants to be sitting in a car for 2 hours each way to go and visit this person who's going to complain and belittle you? Do you know what I mean? Like, that may not be in the best interest of the child. But luckily the child is 14 and will have an opportunity to say, like, yay or nay, I want to see her or I don't want to see her. I know what my vote would be if she were my mama. She's accusing him of unilateral denial of parental rights. She doesn't specify which rights are being denied. Petitioner's motion is legally unfounded and should be summarily denied. So I don't know how it's legally unfounded. There's plenty of case law and data to say that he has grounds for at least consideration of modification. Closed mouth don't get fed. He's not going to get it if he doesn't ask, right? So petitioner and his counsel have engaged in bad faith litigation tactics by filing a meritless motion for continuance. I just put an exclamation point, because this is where she's like balls of a burglar in that the court granted it. So how could it be meritless? The court granted the motion for continuance. If it were basically, she's like, you're dumb too, Your Honor, because you granted this meritless motion for continuance. You should have known better. Looking for flies? Oh, wait, are you putting out your vinegar? I guess you're always looking for flies. You get more flies with honey than with vinegar. She's definitely putting out vinegar. So Florida statute section 61 provides for sanctions against parties who willfully violate court orders. So no sanctions yet because it hasn't been found that he's willfully violated. There's no finding of contempt yet. She just really wants to punish him. You didn't do what they said. Beat, beat, beat. Not understanding, like there's, as Nancy would say, a caveat. Nancy Brophy. Given that petitioner failed to obtain a legal modification before ceasing payment, sanctions are appropriate to prevent further abuse. So that's a question mark. Like, girl, wet? Heifer wet? He's been told he doesn't have to. There's nothing you can do about the fact at this moment that he ceased modification or that he ceased payments without the modification. It would just be backdated to when he applied, when he sought the modification, which, what do we say, 22? Just like when you file for divorce, they backdate it to your date of filing, right? So she just, honey, wants to punish him. So request for attorney's fees due to financial hardship. So this I underline because I want to go to their, let me close these that we already did. I want to go to their marital settlement agreement on this one. So this was filed the May 9th of 2018. It's a lot of standard boilerplate stuff talking about their separation. Let's read some of it. We'll get to the attorney's fees, but some of this may give you a giggle. Neither party shall annoy, threaten, or otherwise interfere with the other party. So do you think the judge will consider all of her tablet messages and her having her flying monkeys call Brian annoying, threatening, or otherwise interfering with Brian? Subsequent divorce, this agreement shall be filed in the pending action for dissolution of marriage, subject to the following. Here we go. Neither party shall make any claim for attorney's fees or costs except in accordance with the provision of this agreement. So this is a blanket and it stands separate and apart from their final judgment. This agreement shall survive the final judgment and be binding upon the parties for all times. This agreement shall be offered into evidence by either party in the dissolution of marriage. And then, is there anything else? Oh yeah, the parties shall comply with the provisions of the parenting plan executed simultaneous with this. So as far as I can tell, Brian is complying as best he can given the circumstances of her being incarcerated. The alimony amount is modifiable upon showing of a substantial change in circumstances, but the duration cannot be extended for any reason. So the duration expired April Fool's Day of this year, of 2025. But it says it's modifiable upon showing of a substantial change in circumstances. Someone being in jail and in prison is pretty substantial. In the event of a modification of the amount of the alimony payments shall be based on the tax law in effect prior to the Tax Cuts and Jobs Act of 2017. So that's, the changes cannot be ruled by this. The Tax Cuts and Job Acts of 2017 is after, apart and aside from whatever happens with this. Personal property. So the parties have previously divided their furnishings and personal property. The wife shall retrieve the remainder of her personal property from the marital home within 14 days from the date of this agreement. Vehicles. The wife shall retain the 2011 Kia Sorento titled in her name as her separate property, free from any claim of the husband. So what does she say in her current document? So here she writes, recover, this is part of the relief that she seeks, recovery of wrongfully retained property. Respondent is the lawful owner of certain personal property, including but not limited to furniture, clothing, family heirlooms, antique Christmas decorations, jewelry from multiple generations. I thought George destroyed all those. Didn't you say that in sentencing? All your heirlooms he destroyed. How did Brian get them after that? Because they're not heirlooms if they're destroyed. I mean, in my opinion, y'all let me know. Respondent is the lawful owner of a 2011 Kia Sorento with 75,000 miles. Please see Exhibit C. So she also got that from my video where I researched the title. During respondent's incarceration, petitioner took possession of these belongings under the pretense of safekeeping, but has failed and refused to return them despite multiple requests. Mind you, this is being written while she sits in Lowell Correctional Institute. Where was he supposed to return them to, ma'am? Drop them off at the prison? But again, this has nothing to do with the marriage. So why is she bringing it to the family court judge, right? Because we just saw in her dissolution of marriage, like, girl, what? They have previously divided their furnishings and personal property. She was supposed to get it 14 days from the date of the agreement. This agreement is dated in 2018. The vehicle, all of that had to happen by April 1st, 2018. She's responsible for the insurance. So I don't know what is happening. Retirement, each party shall retain any retirement funds in his or her name, free from any right, claim, or interest. So that's what I was saying in the last one. I'm not sure because he had two different retirement accounts, but he categorized them separately on two different documents. I think this is the underlying reason why, like, one of them can't be touched by her. And then perhaps he acquired a second one post-divorce, like from 2018 to 2021. And then also conveyance of real property. So the wife shall execute a quitclaim deed transferring her interest in the property to the husband, subject to the following. The husband shall be solely responsible for the outstanding mortgage and shall indemnify and hold the wife harmless from any liability, which apparently she didn't understand what that meant, because in her interrogatory, she wanted to know how much he sold the house for and what he did with his proceeds. None of your business, ma'am. None of your business. Okay. So let's go back to this one. So relief requested, enforce the alimony. She wants the $61,000. Enforce child support. She wants $6,000, which I just don't understand, like, how her brain computes that she needs child support while sitting incarcerated. Order petitioner to provide an accounting of respondent's property and its current whereabouts. Why? Why would Judge Jackson have anything to do with that? That is nothing related to your family case. That happened long after you were divorced. Order petitioner to immediately return any and all items still in his possession. She's not going to do that. She doesn't have jurisdiction. Order petitioner, if any items are no longer available, again, no jurisdiction, having nothing to do with what's going on in court right now. You guys, if that was a separate agreement, you need to file a separate civil action. Award treble damages if petitioner's actions constitute civil theft. She doesn't have the jurisdiction to do any of that. And then she goes on to complain about a bunch of stuff. Hold on. I'm going to look at you guys while I scroll because I think that is it. She asked for attorney's fees, which even if it weren't in that document, she doesn't have an attorney. Typically, you're asking for attorney's fees like as reimbursement. You've already hired your attorney and your attorney is working for you. Like if I say, for example, if Peter and I were to have a civil lawsuit, we would put that in what we pray for, right? Attorney's fees. But that would be what the judge would determine at the end of the trial. So I would have already paid for my attorney. He would have already paid for his attorney. And then the judge would give, as part of the judgment, would award or not attorney's fees to one or the other parties. And then that becomes a part of your judgment when you start filing liens and garnishing wages. That would be a part of that total amount. So yeah, that was it. It was longer than I thought, but I tried to get through it all. That was just like the ridiculousness of what goes on. It's not grounded in reality, her arguments. It seems like, and maybe Owens was doing this too. Hell, for all we know, Sarah was looking up case law in there. Like, you're cherry picking things that kind of fit what you're saying, but in totality, the circumstances don't fit what you're saying, right? Because like in the Hunter versus Hunter, there's no allegation of like physical or actual abuse. There's no criminal contempt that anyone has been found in and jailed for. And the Bowen v. Bowen, or the Lamb v. Lamb, I didn't get those at all. Bowen v. Bowen was where he was arrested for not paying child support. The Lamb v. Lamb, it is totally like they're arguing over who filed for what, and it's getting remanded. So I don't know where they pull those from, but what do you guys think? Like, does she think the judge is not going to do it? Does she really believe like this, that there's some validity to what she's saying? I don't get it. I'm not in the habit of lying though, so I'm not sure, and I'm not saying that you guys are until you have more insight. But it just is like, it just seems so far from the truth. Like if I were going to accuse somebody of like not following the law, I would be very specific about what it is, right? If I'm accusing them in a court of law in front of a judge of violating or breaking or not adhering to the law, I would have receipts. I would really want, because I wouldn't want the judge to yell at me like, why did you say this? Are you making this up? You know what I mean? Let me know. I will talk to y'all in the comments. I appreciate you being here. I'm going to try to edit this down. It's 1:17 right now. I'm going to see if I can get it down to at least 40 minutes. Wish me luck. I'll talk to you guys later. Toodles. Rewatch crew, I appreciate you.